Good morning. Sometimes Siri doesn't translate the way it should. At the first message said the phone and answer committee are ready for you, and so I had to decipher that and make it out. So we're good.
That.
We're good.
I should have proofread that. And I just want to let you know that we're under a 3-minute rule for the presentation of your parts and as well as the witnesses.
Well, look, no problem. So I'll be very brief. I understand that we have some other folks that we need to talk to here, but most of you have heard this before, so I'm not going to go into a whole great detail on it right now. And in fact, I think I'm going to meet with some of my opponents immediately after this and then later on this week. But since I did have some people here that flew in from out of state, I would at least want to give them an opportunity to speak with the understanding that that I voluntarily defer this for 1 week and try to see if we can work this out. So
okay. All right. Thank you. All right. Next up.
Great. My name is Patrick Giacomo. I'm with the Institute for Justice, and thank you, Mr. Chairman and the committee, for allowing me to speak this morning in support of House Bill 702. The Institute for Justice is a nationwide nonprofit law firm that litigates constitutional claims involving individual rights all across the country. We focus most of our efforts on things like occupational licensing, educational choice, property rights, and free speech. And one of the things that we have run into as we try to litigate these cases is that we realize a lot of people have constitutional rights, but those rights are often unenforceable, and in many instances because of things like qualified immunity. And we've heard on other bills this morning, in fact, that there are laws on the books that just are not being enforced. And I would urge that HB 702 allows for the enforcement of the most important laws in Louisiana, which is the Constitution and the individual rights that it robustly secures. Unfortunately, under the current state of the law right now, although everyone in Louisiana has rights against unreasonable searches, unreasonable seizures, and unreasonable invasions of privacy, they have no way of enforcing those rights at all, because there isn't a robust cause of action and there is qualified immunity that stands in the way. What HB 702 would do is solve both of those problems and merely allow individuals to enforce the rights that are guaranteed to them under the Constitution of Louisiana and the Constitution of the United States. But things like qualified immunity are technical obstacles that have nothing to do with the Constitution. Qualified immunity applies something called the clearly established test. And all that test asks is if a government worker violates your rights, whether there was an earlier court case involving the same specific set of facts or circumstances. If there was, you can proceed. If there wasn't, you cannot. It doesn't ask whether the Constitution was violated. It doesn't allow for reasonable mistakes by police officers. In fact, it gets in the way of courts ever addressing whether an officer's use of force was reasonable, whether a search was reasonable, so on and so forth. And so if people in Louisiana actually have the rights guaranteed by the Constitution of Louisiana, Louisiana needs to adopt something like HB 702 to ensure that those rights have actual remedies. I'm happy to answer any questions. Otherwise, thank you so much for your time.
Thank you for being here. All right. Next.
Mr. Chairman, Chris Kaiser, ACLU of Louisiana. Good morning.
Good morning.
Thank you for having me. I would echo a lot of what my colleague, Mr. Giacomo, said. One of the most important functions of our court system in general is to safeguard our most fundamental constitutional rights and liberties. When the government overreaches and deprives us of our life, liberty, or property without due process, or subjects us to an unreasonable search and seizure, our only redress for that is to turn to the courts. We all know the saying that there can be no right without a remedy. If people don't have the meaningful ability to vindicate their rights when they're violated, then our rights really aren't worth more than the paper that they're written on. Unfortunately, we have a situation today where very often our most fundamental rights are rights without remedies. And that's because the federal courts and the Supreme Court have allowed qualified immunity to develop into such a restriction and such a constraint on individuals' ability to vindicate their own rights we just don't quite have a remedy for a lot of those violations. This has led to a situation where people across the political spectrum have been calling for a change, calling for reform. That's why you have the ACLU and the Institute for Justice sitting at the table together. It's also why, for example, Trump appointee to the Fifth Circuit, Judge Willett, has described qualified immunity as, quote, smacking of unqualified impunity for government officials. And he went on to say that the real-world functioning of modern immunity practice, which is essentially heads government wins, tails plaintiffs lose, leaves many victims' rights violated but not vindicated. I also want to note that, a lot of people think that qualified immunity is the thing that protects peace officers from liability when they're making tough but reasonable judgments under very difficult, dangerous, split-second circumstances. But in reality, that's the standard that we would be left with if we got rid of qualified immunity. That's exactly what House Bill 702 is trying to implement. Because the current standard to determine whether there has been a constitutional violation is exactly that. Could a reasonable officer under the same exact circumstances have acted similarly? So if you want to protect police officers from liability when they make those difficult decisions in tough circumstances, but you also think that people should have the right to vindicate their rights when they're actually violated, then you should support this bill. That's exactly what House Bill 702 says. Thank you very much for your time. I will field any questions if you have them. Thank you.
All right. Thank you. Representative McCormick for a question.
Just a quick question, and I'm not a lawyer, not in law enforcement, just a small business owner. What I've seen, the rights have been violated in the past is more by elected officials than police officers. Don't you think we should make this apply to them also?
Well, I would disagree with that assessment. I'm not sure what research you're relying on for that.
The pandemic.
Well, I mean, look, we're getting into a different area, and I understand where you are with that. But this one, and let me say this to you, I'm not opposed to expanding at some point in time, but I don't want to conflate the issue on what we're addressing here. So this bill, I would not be open to it on this bill, but that's something that I would certainly be open to working with you on moving forward.
And that's really not a political question from me. You know me, that's an honest question.
No, I understand,
so.
and I'm telling you, that's not a political answer either.
I agree with that too. I appreciate it.
I would work with you on trying to address some of that.
Thank you. Appreciate it.
Mr. Chairman, also before we move forward, one thing I do want to accomplish while we are here, I do have two amendments that I think will put this bill in its proper posture, and I'd like to see if I could get a member to offer those amendments and adopt those.
Sure. Ms. Pearl, why don't you touch on those amendments? Or is it Ms. Smith?
That's me.
Okay. Go ahead.
Members, we have two amendment sets. The first set is Amendment Set 2490, and it's online. Amendments 1 and 4 are technical. Amendment 2 removes provisions related to indemnification. And Amendment 3 provides relative determination of employment of the peace officer. If employment termination does occur, it does not affect a public entity's liability for payment of damages to the plaintiff. That's the first set.
All right, thank you. Let's talk, Representative Jordan, why don't you talk about that first set of amendments?
Well, so the first set, and I will tell you, this came out of some discussions, not only with both of the gentlemen that you see next to me, but also last year when I met with some of the spouses of law enforcement officials. There was this big conversation about damages being open-ended. Would they have to get private insurance? Would they be at threat of losing their homes and their cars and all this other stuff? And while I didn't necessarily think it was an issue in last year's bill, and I still don't think it's necessarily a big issue, but to allay some of those fears and some of those concerns, what we've decided to do is take, and you'll see from the Second Amendment as well, there would be no individual financial liability, on any of the officers. So this is what that amendment would do. And when you combine it with the Second Amendment, Mr. Chair, quite frankly, and I'm not one I will be very frank with you. I'm not one to get into hyperbole, but I think that if and when this bill moves forward, I think that we have something right now in its amended posture, if those amendments get on, would be the model for the rest of the nation to adopt. And I frankly, I really believe that.
Now, this on amendment number 3, you're striking the indemnification part, or where the actual individual peace officer would be liable up to $25,000. Correct?
No, he would not be liable up to
But
$25,000.
right now, under the current bill,
Under
he
the-
would be personally liable up to $25,000 and would have the necessity of possibly having to obtain individual insurance. And that's what you're striking, correct?
I'm striking. That's gone.
Okay.
That's why.
If-
Let me
if
say
the
this. I
amendment-
don't necessarily agree with the assessment that he would have to get individual insurance.
He could be uninsured.
But because even in that sense, I'll be honest with you. Look, I've been doing this. I've been practicing this area for years, and I've never had any individual officer have to pay anything, regardless of what the amount was. And I can tell you, I've had some judgments that have been way over $25,000. But that being said, to do away with that and to take that off the table, yes, this would not have them liable for anything.
And your proposed amendment would basically give the employer, the public entity employer, just cause for terminating the employment if a court found that the peace officer deprived a right secured by the Constitution. So they automatically would have just cause to fire the peace officer.
Yes. Yes, and I think that's a much better accountability measure than necessarily having them to pay $25,000.
Okay. All right. Representative Freeman.
Thank you, Mr. Chairman. Giving them just cause to fire the employee sounds good on one side, but what happens if they decide not to fire that employee? Obviously, people can make mistakes. They can do things unknowingly. They're, what have you. So, are you now creating a greater cause of action down the road for not firing the person if they keep them on and something, I don't know, something happens down the road again? I mean, are we now creating some prima facie evidence of things?
There might be some negligent retention. It depends. I mean, like anything else. And so, but under that scenario, I think it's the best deal, because what if nothing else ever happens again? Then they're fine. If something else happens, then maybe that's an officer you need to remove.
No, I agree.
Because at some point, if it continues to happen, then isn't it a pattern?
Well, I would agree that if they do it more than once, then you have, one time is you can have a mistake, maybe multiple times is no longer mistakes. But what I'm concerned about is that person, that the employer is going to be really faced with a very tough decision on a person that may have just made a mistake, didn't realize, whatever. Because, these things go from minor to egregious, but it's still violating somebody's rights in some form or fashion. So I'm just a little bit concerned about that. I'm not saying, that it shouldn't be in there. I'm just kind of pointing out some concerns that I may have.
Well, let me say this to you. One, I think the scenario only comes up, even under your hypothetical, if it is multiple times. So that's one. Secondly, minor infractions usually don't rise to the level of a constitutional violation under qualified immunity. It's hard enough to even get past the first threshold. So if the court finds that it's been a violation of a constitutional right, I feel confident in saying that it wouldn't be a minor infraction. So under that scenario, I don't think under either one that's a huge concern.
Thank you, Mr. Representative Jordan. Thank you, Mr. Chairman.
Please don't give me that promotion. Representative Amadei.
Thank you, Mr. Chair. Representative Jordan it seems like Section F, the first paragraph of Amendment Number 3, is not a shall but a may, in that it says has just cause. But don't they already? Don't they already have just cause to terminate someone if a court has found that that peace officer has violated somebody's constitutional rights?
No, because because here's the scenario. One, they could do that, but as Mr. Giacomo just kind of said to you, with qualified immunity in place, if you don't get past that second portion of it, then it's almost like I'm mixing civil law with criminal law, but it's almost like a get out of jail free card. So that's the easiest way that I can kind of explain it to you.
So what you're saying is right now, and
and
I'm only butting in because of the time limits.
Yeah.
So what you're saying is right now, even if a court finds that a peace officer did in fact violate someone's constitutional rights, he cannot be fired. Is that right?
If you don't get to the second part to where there's a clearly established law portion of it, and that's the portion that we would do away with. But I'm going to have Mr. Giacomo speak on it.
Clearly
more.
Established law. It seems that the Constitution of the United States is pretty clear. So.
I would say that too, but that's not the way the courts interpret it.
Yes, so if I may, Representative
Then may I
Amity,
suggest that maybe the courts are the problem? Go ahead.
I agree with that. The clearly established test actually merely asks whether there's an earlier court case saying something's unconstitutional with specificity.
Okay. So I heard you say that in your opening remarks. So what that's telling me is that this peace officer who has been found to have actually violated someone's constitutional rights in a court of law cannot be fired unless someone finds a previous court case where somebody else had already been fired.
That's right. Well,
Okay, now that
it's
is
not about
crazy.
firing.
It's not about firing. It's asking whether there was an earlier court case that said it was unconstitutional. And if it wasn't, a court can stop its analysis there and say it doesn't matter whether what happened here was or wasn't constitutional. The officer is immune, and therefore the case is dismissed.
Because no other case had ever found that he was.
Correct. And
So
the key
what we have then is the courts making law. Okay, thank you.
Yes,
Just
and
wanted to understand that.
if I could add one more thing, Representative, another feature here and why this is so important in HB 702 is that just cause for termination is often determined by the specific union contract that's negotiated by the police with the municipal employer. And so in a lot of instances, that would not necessarily define just cause as violating the Constitution. This bill would ensure that going forward, every contract would have to include that as just cause.
So now we have a court problem and a union problem. Thank you for clearing that up.
You're welcome.
That's all, Mr. Chair.
Thank you. All right. At the request of the author, that he wants to get this bill into the posture which he wanted to present it. Not that I endorse the amendment, but I'm going to move that we adopt Amendment Set 2490. Any other questions on Amendment Set 2490? Any objections to the adoption of Amendment Set 2490? Seeing none, that Amendment Set is adopted. Okay, next Amendment Set 3034, Ms. Pirtle.
Members, this is Amendment Set 3034. It is public and has been passed out. Amendments 1 and 3 remove the right of action of the plaintiff from the individual peace officer to the public entity who employs the peace officer. However, it gives peace officers the right to intervene in the action. Amendments 2 and 6 are technical. Amendment 4 defines attorney fees. Amendment 5 removes the employer indemnification provisions and provides that actions pursuant to this section are not subject to various immunities, legislative and judicial exempted. Amendment 7, it's the same language as Amendment 3 of Amendment Set 2490. That we just adopted.
All right. Thank you. All right. On those amendments.
So what we've done here is went even a step further. So now the individual officer is not a party to the lawsuit. We're naming the public entity. So he would be named in the suit, but not as a party. And then the employer would within and I'm not sure I think it's within 10 days that's in there, but would have to inform the officer of the fact that he has been named in the suit, but again not as the party. And so that at that point he has an unlimited right to intervene at the suit in the suit at any time. So this is just, again, I think one of those measures where we're trying to alleviate any concerns about the individual officers while still trying to protect the public. I think this is a good balance. I think we strike a good balance here, and so that's the goal in which we're trying to achieve.
All right. I'm going to go ahead and offer that amendment set that the author has requested. I move for the adoption of amendment set 3034. Any objections to the adoption of amendment set 3034? Seeing none, that amendment set is adopted. Okay. I think we have a couple of other people who would like to speak in support. We're going to have Marissa Bosley, representing Vote, and David Brown from Law Enforcement Action Partnership. Call them up to the table.
Good morning. How are you?
Good morning.
Good morning. My name is David Brown, and I'm a Louisiana resident. Thank you for the opportunity to testify today. As a Louisiana resident and former prosecuting attorney in Baton Rouge, I'm here today to express my support for HB 702. This bill increases accountability for law enforcement officers who commit serious misconduct and violate a person's civil rights. The Law Enforcement Action Partnership, or LEAP, is a nonprofit group of police, prosecutors, judges, and other criminal justice professionals who speak from firsthand experience. Our mission is to make communities safer by focusing law enforcement resources on the greatest threats to public safety and addressing the root causes of crime. We support HB 702 because we continue to see how communities feel unsafe when police are not held accountable for their actions. Qualified immunity can prevent legitimate cases from being heard when someone files a civil lawsuit because a police officer violated their constitutional rights. The doctrine holds officers and their agencies harmless unless the officer's action has already been clearly established as a constitutional violation in that court's jurisdiction. For example, in Jessup v. City of Fresno, police officers stole money and the victims sued. The Ninth Circuit dismissed the lawsuit on qualified immunity grounds because no previous Ninth Circuit case specifically said that police stealing from plaintiffs is a violation of the Fourth Amendment. When such cases are dismissed, the media firestorm has a devastating impact on public trust in the justice system. Representative Jordan and other legislators have proposed this legislation that would protect Louisiana residents' constitutional rights through state court. HB 702 would allow civil courts to hear cases when an officer violated a citizen's constitutional rights. Officers would not be able to use the qualified immunity defense to keep justified claims out of court. The qualified immunity defense would no longer keep justified claims out of court, helping to salvage law enforcement's reputation for accountability. The amendment also ensures that police would not be held financially responsible. In practice, at the federal level, officers are never bankrupted by these lawsuits. When officers' actions lead to settlements or judgments against them, research shows that 99.98% of the bills get paid by cities. The proposed bill explicitly states that agencies would bear the financial burden. We think this is a very good thing, an important part to have in the bill. Additionally, the bill would also not leave officers vulnerable to a flood of frivolous lawsuits. HB 702 specifically protects against frivolous lawsuits by allowing an award of attorney fees and costs to the defendant if a claim is deemed frivolous. There is a concern being raised by law enforcement that ending qualified immunity would result in officers resigning from a profession that is already experiencing recruiting and retention issues. This is otherwise an important concern, but data out of other states
Please wrap it up.
indicates that's not going to happen. The bottom line is that HB 702 would not bring open season upon law enforcement. It would simply allow judges to hear the facts of the most egregious cases which are currently causing the public perception that police are above the law. It further explicitly protects against frivolous cases. This instrument is a good one, supporting sound public policy and our bedrock principle of checks and balances. Each each of you here today. Now are individual checks to ensure our rights and responsibilities remain balanced. Please support HB 702 with your vote.
Thank you. Representative Wilford Carter for a question.
I just want to make sure that the thank you, Mr. Chairman. I just want to make sure that the cities who's being sued cannot avail themselves of the protection that the law allows a police officer. I would imagine a defense lawyer for a city is going to, whether the police officer a party or not, is going to holler the immunity, some facet of the immunity statute, either federal or federal jurisprudence or so. What's your take on, could a civil suit be defended by using the officer's qualified immunity some kind of way by the city or the municipality, and if the officer is allowed to join in the suit at any time, would he not be permitted or certainly encouraged by his leadership in order to present disqualified immunity?
No, because what we're doing, the amendments are taking the officer out of it, but the bill itself would do away with qualified immunity, so it wouldn't be a defense.
Okay.
You wouldn't be able to use it as defense at all.
Okay, all right.
All right. Thank you, Representative Carter. All right. Next.
Hi, everyone. I'm Marissa Bosley. I'm a law student and president on behalf of VOTE, and I'm in support of HB 702. I'm also the secretary of the first and only National Police Accountability Project student chapter. I testified in favor of Representative Jordan's bill to end qualified immunity back in 2020, and back then I was a first-year law student. Now I'm about to graduate. So what I've learned is the language in HB 702 has really changed for the better for all parties while still maintaining accountability of our state and police. I don't want to repeat too much of what has already been said, so I'm just going to give an example of what clearly established law is. So one major example is the case of Ramirez v. Guadarrama, where in this case there were police officers interacting with someone who was covered in gasoline and suicidal. The officers admitted to themselves that if they tased this man, that it would set him on fire, yet they tased him anyway. The prior cases brought in this court case that were similar ended up being too factually dissimilar to eliminate qualified immunity of the officers, simply because they did not deal with a case specific to a person covered in gasoline and who was suicidal. These officers were not held accountable or liable for this conduct because of qualified immunity as it stands in current law. So basically, HB 702 would address this. A common concern in eliminating qualified immunity is police officers will not do their jobs out of fear of litigation against them. However, when you look at other states that have passed this kind of legislation, this is not the case. According to data from the National Police Accountability Project in Colorado, after the legislation passed in their state, crime rates remained the same and were consistent with similar-sized cities from other states. There are other states like Montana and New Mexico who have also passed similar legislation. Of equal importance to whether we will be able to maintain public safety after limiting qualified immunity is that victims of brutality should be owed reparations from their perpetrators. Victims are victims, and they deserve the appropriate and proper help for the damages and losses that they have sustained, no matter who the perpetrator is, no matter if they were guilty of a crime also. HB 702 maintains this in making sure that they are owed the proper money and help that they deserve. So, like Representative Ahmadi mentioned and pointed out, this is a court issue. You are innocent until proven guilty. So basically this bill ensures that the law of the courts, our judges must determine who is guilty or innocent. So I implore you to pass this bill.
Thank you very much for being here. All right. We're going to go ahead and hear from the opposition. We're going to call up Sheriff Greg Champagne, St. Charles Parish Sheriff, Craig Frosch, Louisiana Sheriff's Association. Oh, so Mr. Mike. Yeah, and Mr. Mike Renazza. I want to welcome my sheriff, Sheriff Greg Champagne from St. Charles Parish. Welcome to the Capitol. So, all right.
Thank you, Representative Miller. Pleasure to see you again.
Thank you.
And also members of the committee. I'm happy to be here, and hopefully I can clear up, or we can all clear up some misconceptions. I am the sheriff of St. Charles Parish and have been for the last 25 and a half years. Before that, I spent 13 years and 8 months as an ADA in St. Charles Parish prosecuting felony cases. I serve as the legal affairs chair of both the Louisiana Sheriffs and the National Sheriffs Association, and have been a past president of the National Sheriffs Association 2016-17. My committee and I have written multiple briefs on the issue of qualified immunity, which, by the way, is only one small part of what this bill is actually about. Recently, I presented testimony on behalf of NSA to a House committee, a congressional House committee in Washington, on basically the misconceptions that have been provided over a long period of time about what qualified immunity is and what it isn't. But this is first not really about qualified immunity. At a time when we have violent crime, which is terrorizing citizens in cities and parishes all over this state, at a time when law enforcement officers are retiring and leaving early as soon as they can in record numbers, which we will not be able to catch up anytime soon, because it takes at least 2 or 3 years before you can get an officer trained through an academy, qualified, with enough experience where we would feel comfortable having them out patrolling the streets of our parishes in Louisiana. At a time when all this is happening, can't we come up with ways to maybe reduce crime, as opposed to finding more ways to sue and prosecute police officers? If you are led to believe that this bill will satisfy your responsibility to ensure the safety of the citizens of Louisiana and keep peace in your neighborhoods, I'm here to tell you you're sadly mistaken. If you have been left with the impression that currently there is no remedy, state or federal, civil and criminal, to prosecute and sue law enforcement officers in the United States of America, this is false. You are mistaken. Currently, and we're talking about the civil realm. So here, let me try to focus it and try to make this simple for you. Right now, there's the most used civil statute to sue law enforcement officers, and by the way, all government officials, which could even include you, who act under color of state law, is contained in Title 42, Section 1983 of federal statutes, federal codes, the United States Code. Those rights, so when it says you can sue an officer for intentionally violating the constitutional rights of a citizen, it doesn't tell you exactly what that means. The way we learn exactly what that means is through decisions of the United States Supreme Court that have come down for decades and decades. That is the basis of training manuals in police academies, including my own. That's how we train. We train based upon the use of force standards, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment, conditions of confinement in correctional facilities, First Amendment. We train based upon that. There is no codification of exactly what constitutional violation. We can only go by the United States Supreme Court. And by the way, while I'm talking about the United States Supreme Court, as late as October, the full 9 members of the U.S. Supreme Court upheld the doctrine of qualified immunity in at least 2 cases. That includes the liberal members.
And Sheriff Champagne,
I know it's 3 minutes.
Please wrap it up, but I know we have a question.
Give me one more thought.
Sure.
Qualified immunity does not mean you have to find a specific case where the court said that. The court has repeatedly said it just needs to put it out in a reasonable fashion to where reasonable officers can have a reasonable notice of what conduct constitutes the violation. It is designed to not be an ex post facto law, to where you know what you're doing may be unconstitutional. It would be the same thing, and I'll finish with this. If you passed a law saying that as far as an ethics violation came out, that we're not going to tell you what it might be, legislators, but that'll be decided when it gets to the ethics board or later in the courts. You'll find out whether or not what you did may have constituted an ethics violation. That would be a similar principle if we didn't have qualified immunity. Just knowing what it is and receiving the guidance. It has been mischaracterized and overdone. So thank you so much. It's hard to do. I could go on for long.
I understand.
But, 3 minutes.
Should take a question from Representative McCormick.
My question is for Mike Renata.
Well, let's hold off on that until we hear from Mr. Renata. Okay, Mr. Frosch.
Mr. Frosch, please,
All right.
first.
Thank you, Mr. Chairman. Committee members, Craig Frosch, General Counsel for the Louisiana Sheriff's Association. I have worked representing sheriffs and their deputies for 29 years, most of that with my predecessor, Alan Usry. And I'm here to let you know that, we've listened to these things for 3 years now, and I just wanted to try to correct this fundamental misunderstanding that's been floated, that qualified immunity is an absolute bar. It is not. The Supreme Court has said that there are some cases where it's clear that an action violates the Constitution and you don't have to show previous cases. That's law, okay? And that's on the federal side. As far as the state goes, there are remedies. No one is out there without a remedy to address any wrongful act committed by a law enforcement officer. Article 2315, we're all familiar with it. All the lawyers know Article 2315. It says, every act, whatever of man, that causes damages to another, obliges him by whose fault it happened to repair it. So you hurt somebody, you caused damage to somebody, by your fault, there's a cause of action against you. Law enforcement officers are no different. They're sued today, they're sued yesterday, they're sued 20 years ago, 30 years ago, under state law. You can go to federal court, allege a constitutional violation, and append state law claims to it. You can pursue that in federal court today, yesterday, 30 years ago. You can do that. Qualified immunity only applies to federal constitutional claims. There is one case in Louisiana law that's sort of an outlier, but I'm telling you, in 29 years of doing this, that has never been successfully pleaded in any other case. We don't even use it because it doesn't apply. There was a tax several years ago, last year, on the discretionary immunity. Again, the court cases dealing with discretionary immunity basically have written it out of the law. So that's not available to a law enforcement officer under state law. What is functional under state law is a standard of reasonableness. And that standard of reasonableness applies across the board. Excessive force cases, false arrest cases, malicious prosecution cases, seizure of property cases, all of these things can be actionable under state law. And it's a standard of reasonableness. And that's a sliding scale. Thank you. In short, we believe that this legislation is unneeded. It's unnecessary. There are adequate, more than adequate, availability of remedies. Representative Jordan said it. He's been doing this for a long time. He's collected judgments over $25,000 in some cases. And I tell you, they go much higher than that at the federal level and at the state level. What I'm saying is this is unnecessary. It's a mess, and we urge you to reject it.
Thank you. Mr. Renatza.
Mr. Chairman, members, Michael Renatza, Executive Director, Louisiana Sheriff's Association. Our membership voted to oppose House Bill 702. As you recall from last year, following the Police Reform Committee, we actually sat before you and supported what was being offered at that time. That was the consensus of the entire Reform Committee. This bill is entirely different. This bill is not written in the same spirit of compromise. This bill is not what was discussed last year. This is totally different. For that reason, we're opposed to it. It's punitive in nature. It has nothing to do with qualified immunity. This bill is about money. I ask you to understand that we feel that we certainly could not fix in 1 week what was discussed for over 4 months last year. We know that a 1 week interval will not fix this bill, and we ask that you defer the bill today. Thank you.
All right.
Thank you. We take a question from Representative McCormick.
Yes, sir.
Thank you. Representative McCormick.
Thank you, Mr. Chairman. Thank you, Mr. Renata. I think you kind of answered most of my questions there, but last year I supported this bill. I wasn't on this committee, but I supported the bill when it come to the floor based on talking to both of my sheriffs, and they asked that I followed y'all's lead. It's a Sheriff's Association. And I guess my question is, I don't know if you know, this may be a better question for Rep. Jordan. It's my understanding that bill died before it got through the Senate. Isn't that correct?
Yes.
And it seems like we'd be better off to take the bill we were working on and continue to work on that until we get it through that process before we start over with a different bill.
Following the instructions of my membership, and after what we consider to be a debacle last year, I have been instructed to not go down that road again.
Okay, so yeah, and I got you. Okay, that was the answer to my question. Thank you.
Yes.
Thank you. Representative Wilford Carter.
Thank you, Mr. Chairman. This bill as amended, you understood the amendment?
Yes.
Several of you said it doesn't deal with qualified immunity. It's in fact take qualified immunity out. Period. And it also takes the police officer out, the individual police officer out. So I don't know. You're protecting the individual police officer under the amended version of this bill. It's broader than, it's more protected here than we've ever had in any bill in the history since I've been here. In the few years I've been here, and even before I was here last time for 9 years, I never seen a bill that says police officer don't even have to be a part of the suit. You can't get a judgment against a police officer. So you're speaking against the people you say you're trying to protect. The police officer can no longer be getting a judgment against. Now, I can understand concerns with regard to the Sheriff Association, the sheriffs. So I'm curious to how the sheriff deal with potential claims for violation of civil rights. Can anybody tell me that much? How do you pay insurance for it, or do you put money aside for it? How you deal with that?
There are different ways to do it, Representative. And to start with, let me say again, it has nothing to do with qualified immunity as it exists today, because qualified immunity as a defense is only available in federal civil rights claims. And this body, this legislature, this state can't change that. That's made by the federal courts.
I understand that.
In state court, it's not available.
You said there's no state statute that deals with any type of immunity for a police officer.
That is correct.
Okay. All right, so how you deal with funding or potential loss for an action for violating the civil rights?
A sheriff may try to get private insurance to cover that. A sheriff may try to be self-insured for that, where he sets aside a reserve to pay judgments against his agency. The Sheriff's Association also has, by statute, a risk management agency that a sheriff may belong to that operates similar to an insurance company and provides coverage to sheriffs who enroll in that program.
Okay.
One thing about this bill is, with the amendments, it takes out the exclusion for criminal acts. Right now, most insurance policies, you have them, it will not cover you for a criminal act. This bill takes that out of the equation. Essentially says, the law of contracts, well, let's throw that out the window and say you can't you have to cover that. There are just so many tentacles with this bill that go the wrong direction.
Okay, I'm trying to understand your concern. First of all, you can have insurance for this?
You can, but it kind of goes in, let me say this, it kind of goes in waves, okay? Insurance companies, private insurance companies will come in and write these policies for a couple of years, 2-3 years, and then they're gone. And the sheriff will be without coverage because it's too risky for them. It's too expensive for the insurance companies to write these policies, and they'll just abandon the state. They won't write them anymore.
Okay, I've been practicing.
We need to move on. Representative Carter.
I'm trying to understand this question. I've been practicing law for 47 years, and I had a lot of these suits. I never sued the sheriff department. I sued cities. So I don't know what's that all about, but I think the sheriffs do have access to insurance for such coverage, and more important than that, most cases that's a limitation how much you can sue a city for, a municipality for. There's a monetary limitation, like $500,000.
That's correct.
Now, but if you go in federal court and you successfully prove any violation of civil rights, then the attorney's fees is open. It's open season.
That's correct.
But then you face with the federal law upon similarity of qualified immunity, stating for a quite similar case. So that's the problem. But this bill, as it's presently written, it doesn't prevent a police officer being prosecuted criminally. And in the past, police officers prosecuted criminally did not prevent a municipality from being sued. So I don't get what you're saying there. I am concerned of what it costs the sheriff department to handle these cases, but I think they do have access either through the association or through individual insurance company.
Well, what this bill does is it adds this is an additional cause of action. So this is triple jeopardy. If you lose in federal court, hey, go to state court. Try to get your attorney fees. Try to get punitive damages. You tell me that any private insurance company is going to continue to write these policies. I suggest not.
All right. Thank you, Representative Garofalo, for a question.
Thank you, Mr. Chairman. Mr. Renazza, Sheriff Champagne, Mr. Frost, thank you so much for coming to testify today. You're filling in a lot of holes for me. What I'm understanding you saying is that we already have remedies to accomplish the stated goal of Rep. Jordan, correct?
That is correct.
There's no need for this bill, that the bill can't be fixed, that this is just going way further than what you guys believe is safe for the public in the state of Louisiana.
Those are our sentiments.
Okay. Rep. Jordan works really hard in this body to try to get things right. I really respect him a lot. I don't personally see the need to delay another week. It doesn't sound like there's going to be any movement in that week. And I understand the spirit of working, but we have people who have come to testify here today who have taken time off of their jobs, who we would be forcing to come and testify again if we delay this for another week. So, Mr. Chairman, I'm going to go ahead and move that we involuntarily defer this bill.
I'm going to ask that you not make that motion at the request of the author, as well as the request of the speaker, who told me that the sheriffs had agreed to meet with the author on Thursday.
Mr. Chairman, with all due respect, I've heard from the sheriffs that they've already met with the author, that they met with the author several times last year, and I understand what you're saying, Mr. Chairman, and I have a tremendous amount of respect for you, but these gentlemen, these law enforcement officers who protect the public in the state of Louisiana, have come here to testify today, taken time off of their jobs. We're going to force them to come back again and testify on the same bill again if nothing can be worked out. I hear the witnesses at the table saying nothing can be worked out. So,
I think personally the bill is beyond repair. Okay. However,
but we agree. Good.
I agree that maybe next week we come back and he'll have to face the music if they have a hearing. But I would like to hear Representative Eccles has a question.
Thank you, Mr. Chairman. I was just trying to be crystal clear on what you've said today. 7 days from now, there's no way, shape, or form that any amendment said is going to get you comfortable with this bill.
No, sir.
7 days from now, do you anticipate meeting with the author to make any headway in any conversation?
I have to meet with any representative as their lobbyist for the association. Whenever requested, I will meet with him, but I do not feel that meeting would be forthcoming to any consensus of the sheriffs in changing their minds on where we stand as an entity on this issue.
So you do not see a time in the near future, 7 days, 14 days, where you would be in favor or even a white card on this bill?
And let me, the point I wanted to make and I didn't because I was trying to rush through in 3 minutes is, it's because we have a body of law. I was describing the federal constitutional decisions that we train on. This would create an entire new body of law in which we would be having to rely upon the future decisions of Louisiana courts of appeals and Supreme Courts to rule on specific situations involving our Constitution, which has similarity to the U.S. Constitution Bill of Rights, but is not exactly the same. So we would have to wait for those decisions so that we can determine what conduct would or would not violate it. That would take a long time. The Supreme Court has been doing this for decades. To say now we're going to open this up to state courts who have never provided us yet with a body of law on the actions of law enforcement in context with the provisions of our state constitution. We don't have that. We're basically putting a law out there now that says if you violate the Louisiana Constitution, you're liable. We don't really know what that means. We can guess that it may be similar to the U.S., but we don't know for sure until the Louisiana Supreme Court tells us. And that's not going to be anytime soon.
I wanted to clarify that while meeting with Representative Jordan, the outcome would not change because I've been instructed to oppose the bill, period.
Thank you, sir. And I, too, tend to agree with Representative Garofalo that if we're not going to have a posture where you either agree with this bill or even neutral on this bill, then there's no reason to kick the can down the road. And I also want to thank all of the men and women that have come today to testify or support you in your efforts. I appreciate your service. Thank you for your commitment and understand the challenges you have going forward. Thank you.
Thank you. Representative Hodges for a question.
Thank you. Thank you, Mr. Chairman. Well, I just want to echo what Representative Garofalo said as well, because our law enforcement, I'm looking, and I know a lot of people flew in from all over the state, took time off work. That takes money, time, and resources. And what we're hearing from you guys at the table, and I've heard from the Fraternal Order of Police as well, that you're not going to come up with any kind of solution in a week. And so if the Sheriff's Association opposes this bill, the Fraternal Order of Police oppose this bill, rank and file officers, that I know some of them are in this room, oppose this bill, I don't see the point of deferring it another week, dragging this out another week. We're more than halfway in the session. We've got officers that are retiring, quitting, can't recruit new members, and so we know that this bill is just going to complicate that further. And so I just would ask the chairman if we could take a vote on this.
Well, we've already had a motion on it, but thank you, Representative Hodges. All right, we're going to go ahead and hear from some more of the opponents. We're going to hear Darryl Basco, Louisiana Fraternal Order of Police, J.O. Quinn, Louisiana State Troopers Association, and Hackley Willis, Louisiana State Troopers Association. If y'all can come on to the table. And good morning and welcome to the committee. Just
Thank you,
identify
Chairman.
yourself.
Thank you, Chairman. Darryl Basco, President of Louisiana Fraternal Order of Police. I'm just going to make two quick comments. One, everyone behind me, if they would raise their hand and you ask the question if their agency is short, everybody's hand's going to go up. This bill, in deference to some of the early testimony, this bill was a carbon copy of the law in Colorado that was passed on qualified immunity. The Colorado Sheriff's Association, Chiefs of Police, and the Fraternal Order of Police did an immediate exit survey of every law enforcement officer that left employment within the next 6 months in Colorado, and 65% of them left because of this legislation in Colorado. So that's point one. You will see an exodus. It's going to hurt us more regardless of what conversations do. It's the idea of qualified immunity. We've been here for about 45 minutes on this bill. Everything that an officer is being asked to be judged for in qualified immunity usually takes in the place of a span of about 30 seconds that he or she is having to make a critical life decision at that point. Just think about that and let that sink in, that for an hour we've been sitting here listening to testimony on something that's going to affect a decision that a law enforcement officer has to make, shall make, within about a 30-second or less time frame. I'll stand for any questions in the sight of brevity here.
Representative Garofalo. Okay. All right. Next.
Mr. Chairman, J.O. Quinn, the Executive Director for the Louisiana State Troopers Association. I'm a recently retired state trooper for 25 years. I retired in February. Not to belabor previous testimony, but what Mr. Basco and others have said is entirely true. Even with state police, we have attrition that we can never catch up with in the foreseeable future. But there's also another issue, besides what everybody else has mentioned about this bill. There's, I think it's Amendment 3, if I'm not mistaken. This, it may usurp some authority from the appointing authority, where we have a separation of powers between the legislative and executive branch. And I am concerned about that. That's something we'd like to see addressed. But ultimately, we're going to be opposed to this bill, just as the Sheriff's Association and all the policemen that you see here are.
All right, thank you. Next.
Aclu Willis with the State Police or State Troopers Association, and I would echo the same things. And to be brief, I've had discussions with Representative Jordan on the bill, and we have reviewed the amendments that he has proposed, and I don't see where a week is gonna fix the issues. We would just ask that it be deferred.
All right, thank you. All right, you have a question for one of the members of the panel?
I just want to verify with you guys, as I did with the last panel, you don't see anything that can occur within the next 7 days, within the next week, that would cure this bill, that would make you guys, make it acceptable to our law enforcement community?
No, sir.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. Next up, we'll call Dr. Michael Carter, Shreveport Police Officers Association, and Kevin Goodwin from the Shreveport Police Officer Association. And good morning.
Good morning. Dr. Michael E. Carter. I'm a 26-year veteran of the Shreveport Police Department. 4 years prior to that, I served in the United States Air Force Police, and I chose to stay in Louisiana and make this my home. Since the existence of the Shreveport Police Officers Association, we have not had a collective bargaining contract between the city. Now, since 1978, this respective legislature prohibits collective bargaining. We do not have that right, so there is no union contract, as previously mentioned in this state, that would disqualify anything that stands now. You have civil service in this state, Title 33. Every individual officer, a municipal officer under civil service, has the same rights as a union member or a non-union member. They have the exact same rights. Any police officer in this state can be terminated, disciplined or terminated under state law. I can show you exactly how to do that. I'm the chairman of the Civil Service Board in Shreveport. It's one written letter dated and signed. The law says currently that the board shall investigate. So if you can't get the department head to do their job, which the law says that they shall investigate also, then you have the remedy. So let's get down to the business of this. This is about money. This is about personal money coming out of a police officer's pocket. Currently, they're indemnified by their cities under qualified immunity. If they do something wrong, it typically goes back to the wrongful or negligent selection, employee selection, negligent retention. If they continue to keep an officer on the job that's not performing to standards, that's not following the rules, and they keep telling them not to do it, and then finally they cross the line, and now there's litigation. That can be done. It's already there. Everything that is accused in this bill of needed, you already have. You already have it under state law. You respectfully have passed those state laws. You have enhanced those state laws. The board actually has to conclude that investigation within 60 days. So if you file a complaint on a police officer within 60 days, you're going to know exactly what the decision is. And then, of course, you have remedies above that. According to the laws passed by this legislature, you can appeal it to the first judicial district court in Shreveport, other judicial district courts across the state, respectfully. Then you can go to the appeals courts, and then you can go all the way up to the Louisiana Supreme Court just on conduct violations. All right, I do not know anyone who has more scrutiny in their job or in their place of employment than a police officer. The truth is that this is about money. This is about suing. So let me make this as brief as I can. You don't just pay a police officer for what they do. You pay them for what they're willing to do. And what most of these men and women are willing to do when they sign on this job is they're willing to go out there and confront people in society that other people do not want to have to confront. Laws like 702, if this becomes law, will bring that discretion to an extreme scrutiny. They will start looking at, I need to stop that car, I need to intervene, that looks shady over there, I need to go and do something about it, to maybe I should avoid this, maybe I should second guess this. You don't want police officers in Shreveport doing that when last year you had a record homicide rate. You want them willing to intervene. You want them willing to go head first in it, knowing the risk to themselves. But 702 puts a risk to their family's financial future. Let them take the risk. Let the cities that employ them, the sheriffs that employ them, take the risk. Don't put this burden on their families financially. Finally, if you want this type of reform, this is not the bill. You start with selection and training. You want police reform, you want better police officers, you look at the selection and training, the training that's required, the education that's required, the individual person, their character that you're selecting to start with. Don't just throw them out there and say, all right, good luck. Because just about anything you do now, you're going to be in court, you're going to have a lawyer with you, and you're going to have to defend everything you do at work. Well, ladies and gentlemen, they'll start doing a whole lot less. And that's not what we need law enforcement in Louisiana to be doing right now. We need them to be doing a whole lot more. We are almost 120 officers short right now, and we can't seem to get below 100. This will affect that.
All right. Thank you, Dr. Carter. Mr. Goodwin.
Yes, my name is Kevin Goodwin. I'm a captain of the Shreveport Police Department. Been there 31 years. I'm not going to be very brief. This will affect our officers staying or leaving. We represent almost 450 officers in Shreveport, and numerous, I could guarantee at least 25 to 30 has told me personally they would leave if this bill passes, including myself. I will not police after 31 years if this bill passes. Thank you.
All right. Representative Garofalo for a question.
Thank you, Mr. Chairman. Dr. Carter, Captain Goodwin, appreciate you coming to testify again today. Just want to go over the same things. We already have remedies in the state of Louisiana for the type of problems that are stated that this bill is supposed to be fixing, correct?
Yes, sir.
And there's nothing that you see that we can do within the next 7 days to make this bill or put this bill in a posture that it would be pro-law enforcement.
I've had extensive conversations by phone with Representative Jordan, and I have a great deal of respect for him.
As do we all.
It's impossible not to like him. The more I talk to him, the more I like him. I will not resolve on this bill. My members wouldn't allow me if I could, but I see nothing good about it.
Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative Seaball.
Thank you. I want to thank y'all for coming down from Shreveport. I know how difficult that is because I make the drive every week. If this is deferred a week, are y'all going to be able to come back next week?
Costs us another $2,000, but we'll be here.
Okay.
I ask that you don't defer it, but if you do, we'll be back because it's our job.
Well, I guess that's where I'm going. I from listening to the members of the panel, I don't see this bill passing. And then the only question is, do we defer it this week or do we defer it next week? But y'all would again have to take a day off work,
Yes,
or at least one day off work,
Yes,
to make the trip and come back down at additional expense if we are to put this off another week. Is that correct?
Yes, sir.
Yes.
We would ask you to defer it today if you would.
All right. Thank you.
Thank you, Representative Hodges.
Thank you, Mr. Chairman. I just want to say thank you guys for being here. Just echo what everybody's saying, and to everyone in this room for taking your time to come. But more importantly, thank you for putting your life on the line every day when you walk up to a car to give a ticket, maybe for speeding or something. You don't know if you're going to get shot in the chest, and those things are happening. And so I applaud you, admire you, and can't say thank you enough. And I think from the entire committee, and for what you do for putting your lives on the line and your families as well. And so I just want to say thank you and God bless you.
Thank you.
Thank you.
All right. Thank you, Representative Muscarello.
I just want to say I opposed the bill last year. I'm going to oppose it this year. But I also feel like it's a courtesy to my colleague when he says he wants to voluntarily defer the bill, that I grant that. So that is not an endorsement of the bill. Just wanted to be clear.
Thank you.
All right.
Thanks, sir.
Thank you. All right. I think the board is clear. Oh, Representative Boyd had a question.
Yeah, I have a couple of questions and comments, and anybody who wants to come up and answer can. I come from a family of law enforcement. My cousin was actually killed doing a domestic violence, so I definitely get what you guys are saying. Two parts. One, if we're already significantly below the staffing, how could this bill affect it anymore? Because they're not leaving and retiring because of the bill, because the bill's not in place. That's first. Second is, if we have laws already in place that kind of support this, are they not being shored up right now? Is that the need? And I guess maybe that's for Representative Jordan. I'm trying to understand why you guys are so opposed to it if the laws are already in place already.
holding a police officer accountable, the law is already in place. I think what the problem is that the citizens of Louisiana do not understand that the laws that you've already passed. You've already developed a structure, and civil service does not prevent anyone from being disciplined or fired. Matter of fact, it makes it a lot easier. It's procedural. They have to follow a procedural process. I've done a lot of educating with activists over the last couple of years, and if they were here, I know that they would say that now they understand. Now they see the process. They see the procedural indications. The term piling on is what this bill would do. It's hard for us to retain now. It's very hard for us to recruit and retain. You'll pile on, and people like Captain Goodwin and myself will retire. But there'll be a few stuck in the middle, like Sergeant Sudis that's here with us. But the ones that are down on the bottom, that are on the fence, do I go to Texas and make $97,000 a year doing the same job, or do I stay here? I think you'll push them over the other side of the fence.
So in essence, really, a huge part of the problem is also the pay. You guys, and I totally agree with that. My brother actually retired from the police department because of pay and moved to Texas, by the way. But so yeah, I was just curious because I hear everybody saying the laws are already in place. So clearly, either the public is not aware of what they can do in those circumstances, and would this bill help shore that up, or is there no meeting of the minds here on trying to work out, maybe even educating the public more on what they can and can't do?
Oh, I think that educating the public is a great thing, and I take the opportunity to try to do that every chance I get. I think people find how open police unions are to police reform. We don't want bad cops. We don't want them. We don't want them amongst us. It's like any other place where you work. You don't want to be considered one of those bad employees. You want your honor to be intact. You want your respect to always be intact. I have personally written letters to district attorneys asking to indict police officers. That's a hard thing to do. But I wrote it and I signed it on letterhead, and I've handed it to them. I can show that to anyone. Over the last 2 or 3 years, doing a lot of the conversations, I think that we've developed an entirely new respect, which I wish had always been there. But circumstances cause communication, and I think that we're getting there as a career field, as an occupation. I think that we're becoming a lot more transparent, and I think that some of that was we weren't as open as we should have been, but that's part of the trade. Post-traumatic stress causes you to get away from people. You don't mix with people. You don't go to the parties and hang out after you become a law enforcement officer, because honestly, you need to get away from people. You need to take a break whenever you can, because when you're on duty, it's 100%. It's a hard job.
All right. Thank you, Representative Boyd. All right. That's all the testimony we'll have. Let's call Representative Jordan back to the table to close. I'm going to go ahead and read some additional cards. Present and will provide information if requested. In support, Chico Yancey from Vote. Not wishing to speak, present in support, Peter Robbins Brown, Louisiana Progress Action. Not wishing to speak, present in support, Julie Schwan Harris. Not wishing to speak, present in support, Frankie Robertson, MUSC, Moms of something Boys. Then we have 30 cards in opposition, not wishing to speak. All of these are in opposition. Present and will provide information if requested. Mike Knaps, Louisiana Association of Chiefs of Police. Not wishing to present and will provide information if requested. In opposition, Karen White, Louisiana Municipal Association. David McDavid, not wishing to speak, present and in opposition for Zachary Police Department. Not wishing to speak, present and in opposition, Chris Stewart, Louisiana Law Enforcement Association. Chad King, Baton Rouge Union of Police. Not wishing to speak, present and in opposition. Not wishing to speak, present and in opposition, Kelly Gibson, Louisiana Fraternal Order of Police. Not wishing to speak, present and in opposition, Hal Hutchinson, Chittimack Tribal Police. Not wishing to speak, present and in opposition, Lawrence E. Callender, French Settlement Police Department. Not wishing to speak, present and in opposition, James Folks, Louisiana Fraternal Order of Police. Not wishing to speak, present in opposition, Mario Brown, White Castle Police Department. Not wishing to speak, present in opposition, Joey A. Fontenot, Eunice Police Department. Not wishing to speak, present in opposition, Dion Boudreau, Law Enforcement, Port Barre Police Department. Not wishing to speak, present in opposition, Chief Randy Fontenot, Eunice Police Department, and the Louisiana Association of Chiefs of Police. Not wishing to speak, President in opposition, Robert Hardy, Law Enforcement, Port Barre Police Department. Not wishing to speak, present and in opposition, Austin Lee, Law Enforcement, Port Barre Police Department. Not wishing to speak, present in opposition, Joe Bourgeois, Lupa. Not wishing to speak, present in opposition, Travis Terrio, Houma Union Police. Not wishing to speak, present in opposition, John Wynn, Lupa. Not wishing to speak, present and in opposition, Licia McCullen, Lake Charles Police Association. Not wishing to speak, present in opposition, Chris Nassif, Lupa. Not wishing to speak, present in opposition, Bobby Branton, Alexandria Police Association. Not wishing to speak, present and in opposition, Brad Walken, Lupa. Not wishing to speak, present and in opposition, Mark Oxley, Louisiana State Troopers Association. Not wishing to speak, present and in opposition, Gary Bennett, Louisiana Sheriff's Association. Not wishing to speak, present and in opposition, Mary Susie Labrie. Not wishing to speak, present and in opposition, Lauren Lampert, Executive Director, Louisiana District Attorneys Association. Not wishing to speak, present in opposition, Linda Mondello. Not wishing to speak, present and in opposition, Cindy Upton. Not wishing to speak, present in opposition, Anthony Sufis, Shreveport Police Officers Association. Not wishing to speak, present in opposition, Paulette Bailey Wilson, City Marshals and City Constables Association. Also, we have received 187 statements, transmittal of committee statements in support by email, I believe, mostly, and 2 in opposition. So, with that, Representative Jordan, I'm going to suggest this, that my committee does not want to hear this bill, but we want to follow the custom, and if you want to defer it without having it being heard, voluntarily defer it. We're not going to hear it again if you voluntarily defer it. If you don't agree to voluntarily defer it, then I'm going to let the committee vote on a motion for involuntarily defer.
Well, I think I started at the beginning by saying I want to voluntarily defer the bill,
with the expectation that you would have another hearing next week. Then
I would like to at least have the expectation of a hearing at some point, whether it be next week or sometime. But look, I understand. I see I have a fan club, and I'm not sure if all those cards set a record for the committee, but if it did, I may take some pride in that. But let me say this: I will voluntarily defer, but I do want to at least make a couple of comments on closing that I think I'd be remiss if I didn't say. One, let me start by saying, even though I don't necessarily agree with his comments, and I know that we don't agree on his issues, I want to say my mutual respect for Michael Carter, because I will tell you, Michael Carter and I have had conversations. In fact, one night, probably, I think it was a Friday night, our first conversation probably was a 3-hour conversation that probably lasted until 11 o'clock, from 8 to 11 o'clock at night. Again, we don't agree on this issue, but at least I think to some level he understands the issue. I am not sure that everybody who put a red card in fully appreciates and understands the issue. And I will give you as case in point. My good friend Larry Freeman last week had a bill that I would suspect that everybody who wants to involuntarily defer my bill on qualified immunity voted for. And it's HB 43. And it deals with firearms. And I'm going to take you to page 4 of 6. And it talks about some other stuff, but lines 7 and 8, and it talks about the Second Amendment. And if law enforcement tries to violate somebody's rights as it relates to the Second Amendment, and line 7 and 8 says, sovereign, official, or qualified immunity shall not be an affirmative defense in such actions. Now, everybody who's talking, Mr. Garrett Fowler, my good friend Valerie Hodges, and others, I looked at the record. They voted for that. They voted for that. The Sheriff's Association didn't come up and put a floor note or speak against it. Chiefs of police didn't do it. City of Port Barry didn't do it. None of those other folks did it. But they come on 702, which I will tell you is a much better bill. Honestly, objectively, I think anybody who looks at this bill will say that it's a much better bill than the bill that we had last year with the Sheriff's Association. It puts many more protections in for the individual officers. And so I certainly took all those things into consideration. But I'm just amazed by the things that people will get up at the table and say. To say that we don't, that officers don't have immunity statutes in Louisiana, that they don't plead, is amazing to me, because I've got a case right now against East Baton Rouge Sheriff's Association. And I can certainly tell you the attorney for them in a motion for summary judgment has pled those immunity statutes. Just looked at them last week. So to say that is either they don't know or they actually know better and said differently.
Please wrap it up.
No problem. So I will tell you, I understand the room. I know how to count pretty well. And I can usually tell the temperature. So I'm going to follow the chair's advice and ask to voluntarily defer this bill, and then we'll move forward appropriately.
Okay, and you understand
that
I'm not going to give the. We've had a full hearing. I will not be rescheduling this bill.
I understand.
All right. All right. Representative Garofalo.
Thank you, Mr. Chairman. Representative Jordan, I just wanted to state for the record and state publicly that I have the utmost respect for you, your professionalism, your compassion. You do a really good job with these issues. But we've heard from all of the opponents of the bill that they don't believe that 7 days will do any good in negotiations. I'm not asking you to comment. I wanted to let you know that that's the reason why I made the move that I did, because I believe that we need our professionals on the street and not in Baton Rouge testifying at a committee hearing.
No, look, and let me say this. I understand a portion of what you're saying, but I just think it's not disingenuous of you. I think it's disingenuous of them to not look at the bill and appreciate it for what it is. So I'm okay with that. I understand it. Well, Representative, I understand where you are. Again, I don't want to waste the committee's time. I've taken the cue from the chair. I understand where we are.
Thank you, Representative Jordan. Thank you, Mr. Chairman.
You have a point of order, Representative Seaball?
Well, the actual motion on the floor is Representative Garofalo's motion to voluntarily defer. And before, if he's going to withdraw that or if we're going to do something different, I want one further clarification. You stated clearly that you're not going to reschedule the bill.
That's correct.
There's one other vehicle, and that would be, since we have had a hearing, he could move to discharge the committee and bring it straight to the floor. I want a commitment from the chairman that you would oppose that.
Absolutely.
Okay.
Thank you. All right.
Based on that conversation, Mr. Chairman, I will go ahead and withdraw my motion.
All right. Thank you. All right. Based on the request of the author, I'm going to move that we voluntarily defer House Bill 702. Any objections to voluntarily deferring House Bill 702? Seeing none, House Bill 702 is voluntarily deferred. Thank you.
Thank you.